I'm Dave Dinkle with our newest Legal Mythbusters series about the idiosyncrasies of quitclaim deeds. As I've said before, these webinars are for informational purposes only and not to be construed as legal or accounting advice. Refer any specific comments or questions you have to info@myfllegal.com. I'm Dave Dinkle, the interviewer. You can see my information at davedinkle.com and besttransactionalfunding.com. Ryan Schroeder Esquire is our guest speaker with Sphinx, Schroeder, and Carnes, PA. And Ryan and I have been indulging in these Mythbuster series, and in some cases they may sound boring to the general audience, but when something happens to you or you have this knowledge behind you, it can be very, very important. So, hi Ryan, how you doing?
Great, Dave, and I'm glad we have you to try to make it a little more exciting.
Oh, yeah. I'm an exciting kind of guy. So what is a quitclaim deed?
Okay, so basically there's three types of deeds out there. There's a warranty deed, a special warranty deed, and a quitclaim deed. And the latter is what we were talking about today, quitclaim deed. Quitclaim deed is a deed or an instrument deeding or conveying property over to another person, real property that is. And biggest difference between a quitclaim deed is that it does not include any warranties by the seller. So the seller is not warranting that they have the right to sell the property, that they own all of the property, that the property doesn't have any encumbrances on it, or any of the other ones that you would receive via a different type of deed.
And that's the reason for the title search and an issue of a title insurance policy when you actually go through a closing. The quitclaim deed is mostly a tabletop sort of transaction, correct?
Yes, because the quitclaim deed doesn't have any of those title covenants or warranties that the other ones have, you usually don't see them involved in any sales or purchase of the property or transfers of property unless the transfer is among like an interfamilial transfer, or if it's some type of transfer where you're transferring over to maybe from your business, your personal to your business. Usually it's not involved unless you're not worried about what's on title.
Yeah, for the seller's not worried about it, but this is a big red flag. If you're getting into a transaction as an investor, purchasing that property either for a rehab or to re-wholesale it or do something with it, and it can only be transferred by quitclaim deed, all sorts of flags should go up. But let's talk about when it's most often used.
Yeah, and let me double back to that. If you're paying any type of significant or even anything less than minimal consideration, if you're paying any type of money that you're worried about losing, you should be worried about receiving a property with a quitclaim, because you're essentially, as a buyer, saying, I'm buying this or I'm accepting this property from a seller without any promise or warranty that they even own it.
Wow.
So you shouldn't do it unless you're familiar with real property transfers or that specific person. And that will go into when it's most often used. It is most often used when a buyer is receiving it from a seller that they know, like a mother or father transferring property to a son or something to that type of situation. But there's some investor uses of it as well.
But the person receiving this quitclaim deed for the property has to understand that whatever is attached to that property is now attached to him also, correct?
Whatever is attached to that property, there will be no legal recourse for that buyer to recover any losses. If there is a lien on that property or a mortgage on that property, that will remain on that property. Yes.
So we talked about land trust in another one of the issues, and this would be a reason why you'd want it in a land trust rather than an LLC that you use on a regular basis or your own name very specifically, right?
Yeah, and to delve in that a little bit, sometimes in the investor situation, they'll come across a property that may be encumbered with all types of liens, municipal liens, code violation liens, and they'll say to somebody, hey, why don't you just, quitclaim the property over to me, and then I'll work out those liens and different types of things. And if it doesn't work, what's the big deal? It's already, the liens on it and everything are already more than what the property's worth, so I'll just walk away. And where that becomes a major problem is if you're receiving and own property that has liens and things that continue to run, like a city lien, any type of super lien. Code liens are a good example. Code liens are what they call super liens, which means the city has a lien against an owner of property. It attaches to all properties that owner owns in that county. And they theoretically could take that lien they have against the owner of that property and report it in other counties. So you do not want to just receive a property from a seller via quitclaim that has code liens on it. And when those liens continue to go against that property and start accruing against the new owner, that could affect other land you own as well.
What about his homesteaded property? If an investor had his own property in his own name and he was unfortunate enough to not realize this and took took the quitclaim deed in his own name, would that potentially tie up his own property if he went to sell it?
If you have a code lien against you, it's going to affect your personal homestead. You can ultimately sell your homestead, but it is more hoops that you have to jump through. You'll have to do a notice of homestead to get that lien removed so you could sell your homestead, maybe buy another one, or if you want to refinance. So it adds some barriers. It could complicate things even with your own homestead.
So the two biggest places that I see these quitclaim deeds is first, as we discussed, where somebody is trying to transfer you a headache they don't want anymore, and you're going to take it on. The second one is a dying parent signs one before or on his deathbed. But what happens if there's more siblings and he signs it over to only one of the siblings?
So that question could have a lot of possibilities to it. So I want to narrow it a little bit so we don't go down rabbit holes. But if a dying person signed over a deed to someone, whether that is one heir, one of their children, whether it's their best friend, etc., that would still theoretically be legal as long as they were competent and etc. Now, if it's the dying person's homestead, like I said, you have a lot of different variables. They couldn't sign over their property without their spouse joining or some other type of situation. But technically, that quitclaim deed would still be legal if it was executed correctly and delivered to the one sibling. And the other siblings would be out. But whenever we see in the title industry quitclaim deeds, it raises somewhat of a red flag, and we look further. And so what that would make us do, if that one heir tried to go sell, we would say, hey, why was it done by this in this manner? And then is there a potential possibility that those other heirs are going to come out and say that that was incorrectly executed? Maybe it was fraudulent, they weren't in the right state of mind. Any type of the different variables that could invalidate a deed are likely to come out. And so when you see that quitclaim deed on the deathbed, there's a good chance that there could be issues involved. And that's why you might have insurability problems.
A lot of people don't understand is that when a quitclaim or any other deed is recorded in the public record, it's not scrutinized for its validity. It's just simply recorded. And if it's not a valid or it's fraudulent deed, that has to go through the court system later, correct?
Yes, excellent question. A lot of people believe that when they go on the property appraiser's website and they see that it says so-and-so is the owner, that's the owner. And that could be because a quitclaim deed could have been forged or, somebody pressured into, or whatever the situation is, could have been executed. When it's taken to the recording office, they don't look at validity of it, whether it was done correctly or not. They record it. And so their job is not to oversee, they're not a court. They put it up there. And then the property appraiser, when they get them recorded, they change the name. So when you're buying property and you see that the seller inherited it via a quitclaim deed, it raises red flags. And you should not just assume because you went on the property appraiser's website, saw that John Doe owns it and they received it through a quitclaim deed, that if you buy it from John Doe, that you're going to own the property. And that gets back to the discussion we had one question ago. The underwriters know this. The title insurers know this. And that's why if they see that transfer done via a quitclaim deed, they're more hesitant to insure it because they want to make sure there's not going to be an issue where they later have to pay out.
Yeah, I've seen where a parent who had a homesteaded property quitclaimed it to one of her siblings, and then later, for some reason, he quitclaimed it back to her, but she lost her homestead exemption that she had, and her taxes went up dramatically. So if you're playing with these quitclaim deeds, you have to be careful about the consequences of them, so to speak.
You have to be very, very careful. Well, the only way local government in Florida is able to tax is through the ad valorem taxing. And when you have homestead on your taxes, it's less that they can tax. So they've become pretty creative. And anytime there's a transfer of the property, whether that be a quitclaim deed or not, they will remove the homestead exemption. And you have to make sure that the buyer who received it then moved into it, they have to make sure to reapply for the homestead or whatnot, because it behooves the county and the property appraiser to take off that exemption so they can tax more. And that's precisely what happened in the situation you're talking about. They executed some type of quitclaim deed. When it was recorded, it automatically triggered the removal of the homestead. And when they transferred it back on, there was probably no reapplication. So the taxes went through the roof.
We talked about this basically, but are all liens and personal judgments on a property transferred to a buyer who accepts the quitclaim deed?
Yeah, so essentially all liens and judgments on a property are transferred or remain on the property, whether it's a warranty deed, special warranty deed, or a quitclaim quitclaim deed. The big difference is you have no recourse when you receive that property via a quitclaim deed. So if you receive a property via a quitclaim deed, you owe legal recourse to go back after the seller. And if you've given any type of money or consideration, it's not that they tricked you. What happened was you got it as they had it, whether that's nothing or everything on it.
What about an IRS lien?
Anything that attaches to the property is going to transfer with the deed.
So we talked about this. Are super liens also transferred? I want you to just touch on the super liens again, because most people don't understand this. And in other counties, they may not have this structure of the super liens. Is this a statewide thing?
Yeah, under state law, certain liens are super liens. And so municipal liens and governmental county liens, they're going to be super liens, meaning they have super priority. It's not that a super lien is transferred to a buyer via a quitclaim deed, and if it was a warranty deed, it wouldn't be. It remains on the property, but the issue is, with the practical application comes in, is when people are using quitclaim deeds to obtain property, it's usually because, like you said, the property is a mess. And those liens that are there, or the issues creating those liens that are there, continue to happen. So if there's a lien from the city for having a bad yard, but it was corrected, when the buyer receives the property, they don't run the risk of incurring additional liens. And so that's going to remain on the initial seller and against that specific property. But the issue is, or practically speaking, when you're receiving it through quitclaim deed, you think, hey, I'm not paying anything for it. Let them transfer over this. That's continuing to incur liens. And if it doesn't work out, I'll just walk away from it. And that's the problem, because you're receiving it through the quitclaim deed and you're now the owner. All those continued concurrent running violations are going to be against you as the new owner and going to attach to anything else you own. And that's why before you accept the property via quitclaim deed or any type of deed, you better make sure that if you own another property, that you're going to get that thing in compliance immediately upon your ownership, or you want to receive it in the name of a separate entity like a land trust.
Like a throwaway entity, in effect.
Exactly. So if you're going to acquire a property that has continuing violations or something via quitclaim deed for nearly no cost, you may buy it or receive it in the name of what you said was a throwaway entity or a land trust. So if you're unable to correct the problem, say the issue that's incurring liens is something structural where without significant money you wouldn't be able to rebuild it or correct the code violation or whatever it is, and essentially you're hedging your loss. You can always walk away for what you spent versus not being able to walk away because all those violations are incurring in your personal name.
So the question comes up is, why are certificates of deeds, which come out of a tax deed sale, most often transferred by a quitclaim deed from the person that wins the auction, so to speak, to a buyer coming in?
So somebody who's acquired a property through tax deed is not usually willing to resell that property with a warranty deed, and is only usually willing to do it with a quitclaim deed, because tax deed sales, inherently the way they're conducted by the county level, not at the court level, inherently have issues where they miss things, they miss notice or whatever. So it's so common that they have issues, it's uninsurable. You can't resell that usually unless 4 years has passed or you've actually gone out and got a quiet title suit done. Because of that issue, it leaves somebody who purchases property at tax deed sale usually saying, hey, either I got to do a quiet title suit to be able to clear any clouds on title and then sell this property with title insurance with a warranty deed, or I'll just quitclaim it over to you and you have what I got. And basically that seller who got it from the tax deed sale saying, I don't know what I have here. All I know is I bought it at the tax deed sale. I don't know if they did it the right way, they did it the wrong way, but here you go. And whatever I got, you got now. If what I got was wrong via the tax deed sale, there was an error in the sale, well, now you got that wrong. And it limits the seller's exposure because they're not promising anything other than you have what I have.
Okay, so let me ask you a question. In a foreclosure sale, it's very important for the attorney that's filing the lis pens to put all of the potential lien holders on the suit. And if he leaves any of them out, they're not knocked off in the foreclosure as junior liens. But in a tax deed sale, does the same thing happen where everybody in the chain of title is supposed to be notified of the sale?
Yes, precisely. But the difference is one is done more administratively at the county level versus it being done in an adversarial manner at the court. And so when they do the foreclosure suit, you can only wipe out somebody's interest if you let them know that their interest was being wiped out. The foreclosure lawyer runs title and he then goes out and physically serves each person with a process server where they publish in the paper and they do all these different things to make sure that their conformance with due process appropriately naming and wiping out these other interests. And the problem, what happens with the tax deed sales, is it's not done with the courts. They don't require the county to go out and physically serve with a process server this person or that person, or to do an affidavit that they can't find them and publish. So it's a lot less sophisticated of a sale, and it's done just through really some certified mailings, and that results in a lot of people being missed or errors. And that's why, in order to insure it, a title insurer will say, hey, we got to see 4 years run, which means anybody who had an interest was lost, never came back, so we're going to wipe them out, the statute of limitations. Or you got to go out and do a quiet title suit and have the lawyers run title and name all these people and make sure we're good to go. And so that might be a little more in depth than most people want to know about it, but that's precisely the difference.
Yeah, the point of this conversation is to be careful. Again, quitclaim deeds are red flags. And we talked about this briefly, but how does a quiet title action actually allow you to resell with a warranty deed instead of this quitclaim deed? And why don't most investors just do it? Because a warranty deed is more powerful and will get you more money on the resale.
What happens with a quiet title suit is you run title and you find out all the names of all the potential interested people, and then you send a process server out with an actual copy of the suit to serve it on them, and then they're required to respond within 20 days of that lawsuit. If they don't, you can default them and you can move forward to wipe out their interest. So what happens is you've actually gone out, you found the person, you handed them a document, they've had an opportunity, notice, and an opportunity to respond to the court, and they didn't, so their interest is wiped out. And so that's a lot more of a sophisticated or of a sure thing on making sure you are including everyone who should be included. Because what happens is if you don't include somebody or let them know of either a tax deed sale or a quiet title, you can't wipe out their interest. They can't have a lawsuit about you, Dave, an interest you own in Alaska without you ever having any idea the lawsuit was going on. That's why the underwriters say, hey, we're not going to just take the chance that these clerks at the county send out certified mail to the right people, and maybe they got it wrong. So we want everybody to be listed, dragged into this, handed the thing, and then, judicial determination that their rights were not properly extinguished. That costs a little bit of money to do. Obviously, you have to hire a lawyer, you got to do it. And so it will usually cost an investor, whoever received it, about $2,500, maybe to the lawyer, and maybe $500 or more in fees. But that results in you being able, or the underwriter feeling confident in moving forward with it. Or they want you to run that 4-year time period because they say, hey, after 4 years, statute of limitations is going to be up. Somebody can't come back or no one's going to come forward. So the whole issue of whether or not you can get insurance, it's not that it's not possible. It's just, as an industry standard, they're not going to insure just the clerk's office sending out some mail to wipe out interest.
I want whoever's listening to this to understand that these were most frequently asked questions, and some of these are somewhat repetitive. This next one, for example, can a buyer get title insurance when the seller will only give a quitclaim deed? And we're kind of beating this to death, but just answer that again.
The majority of the time, no. And the reason why is if an issue comes up, the buyer is going to make a claim on their insurance and the insurance company is going to pay out. So the insurance company wants to have the seller guarantee what they're giving. That's why they want to have them do it via a warranty deed. Now, there are times where it's allowed to happen. For example, in foreclosure sales, Bank of the Ozarks or one of these other banks, Bank of America, they might tell you, hey, you want to buy this property we own, you're going to buy it with a quitclaim deed, but they always pay the title insurance. And people say, hey, I think they don't know that in Dayton, Broward, that the buyer usually pays, so we're getting one over on the bank. No, they know. What it is that Bank of America does so much business, and they go to one of these underwriters like Fidelity or Old Republic or Chicago or First American, and they tell them, hey, we're going to give you all these sales. We're only going to do it with a quitclaim deed. You're going to do it? And so the underwriters have a secondary assessment going on. They know if there's an issue, they have different agreements with those big banks or those big customers to insure it, and they're not worried about those companies skipping out on them. Sometimes you can get insurance with a quitclaim deed, but for the majority of the time, the underwriter is not going to insure something when the seller, him or herself, won't warrant it.
It's kind of a standard disclosure on foreclosure sales that the property is going to be transferred by a special warranty deed or a quitclaim deed. I have never seen a warranty deed transfer.
And not to sidetrack to the third deed there, the special warranty deed. Special warranty deed, basically, the seller is saying, I'm only warranting title from the time I've owned it. I don't know what happened before, but I'm telling you, while I owned it, there's no issues. And so you'll see developers who often will sell with a special warranty deed, and foreclosures, the bank, pretty much sellers who are in a position to dictate and try to do that. But if you're a seller, you always want to sell with a quitclaim deed. You want to not guarantee anything. And if you're a buyer, you always want to receive a warranty deed. You want all guarantees.
I think this is pretty obvious, but when should investors be using quitclaim deeds?
Well, if you're the investor selling it, use it every time you can get away with it. If you're the investor buying it, never use it unless you're forced to. Now, if the investor wants to just deed something over to an entity they own, obviously they're okay with doing it on a quitclaim deed because they're not worried about what they own as the individual selling to them as the entity or vice versa. But anytime they can use a warranty deed, it's actually better. If you have a distressed property and the seller will actually give it over to you via a warranty deed, do that instead of a quitclaim. There's no need for the quitclaim deed if you're the buyer. You always want a warranty deed.
I don't want to get off track, but I think it's important that people understand what a warranty deed actually covers, because sometimes an investor will come back and say, it had a bad foundation, the roof was caving in, it had termites, I didn't know that. But those aren't claims that are covered by title insurance.
No, title insurance does not cover anything to do with building code violations or the condition of the property. And whenever you were wondering about it, think about the fact that title insurance company doesn't go out and look at the property. Title insurance is warranting the ownership of a legal description. That's what it is. Not even the house, because they don't know where the house is built. It's different. If you get a survey, it's a little bit different. But they're warranting the ownership of the legal description of the four corners of the property. And that's why sometimes the lenders will say, hey, we want a survey, because they want to make sure that the house, when it's drawn out, is on those four corners of the property. That's what title insurance is warranting, all of the real property within a certain legal description. And not the condition of it, just the ownership, right to quiet enjoyment, selling it, to be able to sell it. There's 6 covenants that run with warranty deeds, but not to get into the in-depth issues on that. But yeah, it has nothing to do with the actual condition or violation or anything like that.
Okay. When transferring a property to a trustee of a land trust, is it called a quitclaim deed to a trustee instead of a warranty deed to a trustee?
Well, you could actually have any of them. You could have a warranty deed to a trustee. You could have a special warranty deed to a trustee, or you could have a quitclaim deed to the trustee. The actual name or description of it is not operative as to what it is. So it could be, if you were the buyer, happily request or accept a warranty deed to the trustee.
Well, as we said before, do not assume that because these situations may seem similar to something you're already doing, that they are in fact exact copies of what you're looking at. The best way you can find out is access info at myfllegal.com. Ask your questions there. And I want to say again, we're moving forward on these Mythbusters. Some of these topics can sound kind of like boring, but in the real world, when one of these happens to you, it can mean an awful lot of money, either a loss or potential huge gain. Thank you very much, Ryan. Appreciate it.
Absolutely. And just to add to that, Dave, if anyone has any topics that they think need some clarifications, feel free to email it over to me or you, and maybe we could do a video on that.
Okay, super. Thanks again.